Tēnā koutou katoa, nau mai haere mai. Greetings, everyone, and welcome. Welcome to our inaugural podcast show for NZFreeLaw, brought to you by ture.co.nz. NZFreeLaw will be talking all things law in New Zealand. It's for everyone, public and legal practitioners, about things like frequently asked questions that lawyers get asked, and we'll try to answer those best we can. Also, legal theory, cases and hot legal industry topics. So what's happening in the industry and where is it going in the future? We've got a great lineup of guests for the show, including today. But first, I should probably introduce you to my co-host and I. My co-host is Josh Brown. Hi,
Cheers,
Josh.
Josh. Kia ora.
Kia ora.
I speak for the people.
Yeah, appreciate that. My name is Julia Steenson, and I'm a lawyer from the Waikato who's moving into this new digital connecting space as the founder of ture.co.nz in this podcast show. But now to our special guest of the day, Ani Bennett, who's an employment lawyer based in Tauranga, and she's talking to us by telephone. Tēnā koe, Ani.
Ngā mihi nui kia koutou katoa. Kia ora, Julia. Tēnā koe, Josh.
Kia ora.
Happy to be here.
Yeah, thanks for taking time out of your busy schedule to speak to us today. I really appreciate that.
I'm excited because she must have the juiciest work stories. Better work stories.
Which of
All
course
the
are
gossip.
confidential as well.
Oh, yeah,
I'll
right.
have to give
General
them
principles.
pseudonyms before I give you the details.
Now, just a little bit of background. I had the pleasure of meeting Ani at the Māori Law Conference last year. But for the benefit of the audience, Ani, can you tell us a little bit about yourself?
So, my iwi a Ngāti Ranginui from Tauranga and Te Whānau a Panui from Te Kaha. And I was born and raised in Tauranga. I was raised by my grandparents, and my grandmother, interestingly, her grandfather was the first Māori lawyer to practice law in New Zealand. His name was Hāmiora Hay. So Apaniana Ngata was the first to get a law degree, Hāmiora was the first to practice. And so she, quote, suggested, end quote, that might be a good job for me when I was
Lots
a kid.
of talking back and arguing.
Yeah, and being an obedient grandchild, I went, oh, okay, man. Yeah, that sounds like a great job.
Yeah, the old, this is what you're going to be.
Kia ora, yeah. And she was quite a force of nature, my grandmother. She was assistant deputy principal of one of the local intermediates. Matataui Te Reo had grown up as a native speaker in a very strong Māori community in Te Kaha. So she was definitely the boss. And I just thought, oh, wow, this will be a great opportunity for me to be of service to my people. You know, this is how I'm going to contribute. And so I was always going to be a lawyer from about the time I was 8 years old.
Destined, your destiny.
Aye, and here I am, many, many years later, nearly 20 years.
And you
into
said to
the
help
profession.
people?
Yeah.
Have you been able to help people? That was one of your missions? Or?
Specifically, my passion was te ao Māori, you know, helping my community, my hapu and my iwi. And interestingly, all through high school, I was going to be a lawyer, you know, ducks in my school, good marks, got to law school and hated it. I was just oh my God, this is so boring. These readings are terrible. What am I going to do with my life? Because I've got no backup plan, you know. I was just always going to be a lawyer. So I actually finished my law degree because I didn't know what else I was going to do. And thankfully, I did a BA as well, which were all my interesting papers. You know, I did politics and philosophy and world history. It was great. So I didn't go straight into law. I got a lot of scholarships because, you know, I liked being a rich student and having really trendy clothes when I was at Waikato and eating out at good restaurants. A lot of my university, very abundant as a student. Wish I'd saved some of that and bought a house, but never mind.
Yes, I have those thoughts too, back to those days.
Yes. Tip to the young people, think about that. So I bonded through one of those scholarships to work for IRD when I finished my degree. So I'd gone and had a tipi haere. I had an OE overseas, and I hung out with my father's family. My dad's English, from Billinge near Wigan. So they're all, you know, sit you down, love and have a cup of tea. You know, that's my family over there. And I came back and I was a policy analyst in Wellington at IRD, and I did tax policy.
That would have been riveting.
Tax is also boring, but it's very lucrative. So those that are tax lawyers, they're the richest lawyers in New Zealand, God bless them. But I was blessed because there was this wonderful Māori senior policy analyst there called Charles Ngaki. He hails from Te Pukeaway. And they were doing a review of the Māori authority section of the Tax Act. So I got to go around and consult with hapu iwi leaders. It was wonderful. It was really good. And it kept me interested, frankly. But when I hit 26, I had one of those quarter-life crises, you know? Like I woke up and I thought, yeah, it's not like a midlife crisis. It's like your quarter-life crisis.
Yeah, I think I had one of those.
Yeah, I just woke up at 26 and went, oh my God, I'm closer to 30 now than I am to 20. Yeah. What am I going to do with my life? Because I sure as hell don't want to be a policy analyst at IRD, right?
Yeah, and you think, I'm so old now. Is this
Yes,
it?
I'm old and I have to make a decision because this will be my job for the rest of my life, you know, which my older mentors at the time just laughed and said that's not what happened. But so I had to relook at what are my values, what do I want to do, and it came back to Māori economic development, being of service, helping people, and I realised I could do that being a lawyer, and that's how I moved back. That's how I started being a lawyer, and I moved back to Tauranga. I was living in Wellington. I missed Tauranga more. I missed home, and I got my first lawyer job back here.
Ka pai. Well, we're going to move into the next section, the legal word of the day. And so this is a part of the show, Ani, where we introduce the legal jargon that lawyers are familiar with, but the public may not be. And today we've got two sets of words. One is contract for service versus contract of service. Just to give a really basic definition or difference between the two, a contract for service is a contractor. Basically, a contractor that is responsible for their own taxes, etc., doing work for somebody, whereas a contract of service, so that little connector in the middle makes all the difference, is an employment agreement. So basically you're an employee. Is that right, Ani? Does that sound right?
Yes, I agree with that, and I quickly looked that up on the internet when you said that, Julia. So yes. Auntie Google agrees with you, and so does the IRD website.
Well, that tells me that I know something about employment law, so that's helpful. But Josh, you have a lot of contractors that work for you, don't you? So
yeah, but I use the term loosely. It's like they're not an employee, do up a contract, and then there's some paperwork that the organisation has, and we do it up, and they're a contractor. That's as much as I think about it.
But I think there's a bit of danger in that, isn't there, Ani? Because just because you say that person is a contractor and they have a contract.
Tell me about it though. What are the dangers or the nuances of why that's
yeah, this has been a juicy part of practice for employment lawyers and kept them in the fees for many years. So here's the danger. If it looks like a duck and it quacks like a duck, then it is a duck. Yeah. So you can draw up a contract and say you are an independent contractor and you're going to pay your own tax and your own GST and be responsible for your own ACC and I don't have to give you holidays and all that kind of thing. But if you actually treat that person on the ground as if they're an employee, then the employment courts will deem them to be employees and have all the rights and protections under the Employment Relations Act. So what that actually means is how much control do you have over them day to day? You know, do they have to be at a desk in an office at your workplace and you control when they work and where they work? You control who else they can work for, you know? You try and discipline them for breaching the employer policies if they wouldn't apply to contractors. So the more control you have over them day to day, the more they look like employees. So you need to be careful that way. And so things that you do is you absolutely have a written contract saying you are an independent contractor, not an employee. And you've gone away and you've had the opportunity to talk to a lawyer about that, right? And you give them reasonable time between giving them contract and signing it to have gone and seen a lawyer, and I'd say a minimum of 3 working days. But you also don't control who else they work for, as long as it's not a massive conflict of interest for your business. You know, you give them the freedom to come and go as a contractor would.
I guess just with that's with the lawyer hat on. If I put my manager hat and you treat people differently, I feel like from a unity and team point of view, that could undermine. It's like, cool, we're going on team building, except you four, because you're contractors. Or
no, you would have them in that. You could have them as part of the team building. You can still treat them like a whānau.
Yeah, right.
But they can, they can say, "Oh, sorry, Josh, I'm actually contracting for some other people, and I can only give you 20 hours."
Yeah,
right. I'm going to have to end our contract as per the termination clause and give you a month's notice because I've got other things I'm doing. All that kind of thing.
Yeah, okay. So that is quite an interesting little set of words that can catch, I think, a few employers out these days. As you said, it seems to be quite a topical issue. Okay, so we're going to move on now to the legal topic of the week. We do a variation, you see, with our guests. Sometimes we focus on legal practice, which we're doing today, and other times it's on the legal industry or the theory of law. So let's get into it, and I've got lots of questions for Ani, and Josh, I'm sure you have some too. But I'm going to kick off, get straight into it. So you're an experienced employment lawyer, as we've heard from Tauranga office, Bennett Consultancy New Zealand Limited. Can you just give us a brief overview of the kinds of matters that you handle on a regular basis, Ani?
So I work for both employers and employees. So with employees, generally people come to see me when they feel they've been treated unfairly. So that's been treated unfairly while they're still at work, or they've been unjustifiably dismissed. So I assist them with seeing if actually they've got a case at all. And if they do, then we can look at a personal grievance claim, a PG. And that can start at just letters and negotiations with the employer. It can go to mediation, which is usually facilitated by MINBI, the Ministry of Business, Innovation and Employment, i.e. the Labour Department, right? And it can go all the way to formal legal hearing at the Employment Relations Authority, so court. Generally, I'm setting up systems to help them avoid needing an employment lawyer in the first place. So that's making sure they've got good employment agreements, good policies and practices in place. And quite a large part of my practice these days is focused on positive psychology, happiness, high performance in the workplace, and trying to avoid those conflicts and those issues that can fester away and blow up into misconduct, disciplinaries, PGs.
So when you say personal grievance, and then you're referring to, just for the benefit of the audience, can you just unpack that a little bit?
So a personal grievance is what the term you use when you're going to sue your employer, basically. And under the Act, the Employment Relations Act, that's the term that they use. And there's two types of personal grievance. So there's one when you're still in employment, and that's called unjustified disadvantage. Something has happened to me that's been unfair and I've been disadvantaged, like my employer just cut my wages without telling me. My employer just slashed my hours without being able to do that under the contract. My employer yells and screams at me and throws staplers across the room, right? And then there's unjustified dismissal. So that one is obviously when you're not at work anymore. You've been fired, or they've just made it so appallingly terrible you felt you had no choice but to resign, and that's called constructive dismissal.
And so Josh was actually...
I didn't know about these two.
Josh sat down and the first thing he said to me was, so I'll be able to ask Ani, when is it right to approach an employment lawyer if you've got an issue?
When do people come to you?
I always say to my clients, 10 minutes on the phone with me will probably save you hours and hours and thousands of dollars down the track. And I don't charge for those 10-minute chats with my clients. It only turns into, let's open a file and start charging some money if that issue really is starting to snowball. But there is a natural tendency I found with people to avoid conflict. And so they go, oh, okay, oh, well, that's past. Let's just go back to pretending everything's fine and hope that doesn't happen again. Just carry on to the next explosion, right? Or the next incident or the next thing that wears away. So I often get people that ring me up, say, example, an employer going, I just can't take it anymore and I want to fire this person tomorrow and I'm just ringing you so I don't get sued, Ani. Right? But I'm doing it. We're having a meeting at 10 a.m. tomorrow morning. And my first answer is, no, you're not. You're going to cancel that meeting. Because people have just not dealt with it and not dealt with it and not dealt with it and just boom, suddenly it becomes a big issue.
It's quite fascinating because it is kind of the Kiwi psyche is, we do it even at restaurants and anyway, we're a bit passive-aggressive, really.
But can it be too early, though? It's like, oh, we've had one dust up. Is it time to start talking to an employment lawyer? That feels too early. Like, still, when would you?
I mean, as with all things, actually, you have to feel it out. Yeah. I think as a young lawyer, and I think all lawyers learn this, you learn to tap into your gut instincts. That client that rings you up and you could get a feeling they're a bit mad and you shouldn't touch it, but you do anyway. Yeah. And then they're just the nightmare client that you have to keep file notes on and they're going to complain to the Law Society, and you learn, I will never distrust my puku again.
Yeah.
And that's often the discussions I have with my employer clients. Like, oh, this person, Ani, I've just got this bad feeling and it keeps coming up and this is what happens. So we talk about it. What I have seen over the years is employers that tackle things early and set healthy boundaries about how we're going to treat each other around here. They take those lovely words that are often up on the wall, our mission statements, our principles, te tikanga, o te rōpū nei, our whanaungatanga, manaakitanga, all that stuff, all the tangas, as one of my mates said, all the tangas. They take those things and they actually apply them to the discussions that they have with their employees, and they deal with stuff early. How often do you find that
occurs? Because I find that it's sort of quite a rare occurrence that the values are talked about. I mean, at the wānanga, we talk about them constantly. It's incredibly well, everybody knows them and everybody talks about them. But at other organisations I've worked for and with, you mention the values and they look at you like you're crazy.
It can be seen as a bit emotional, I think. Often people that tend to rise into management positions are often people that are their personalities are more focused on strategic, goal-oriented solutions, not so much emotions and relationships, right? That seems to be a natural thing that can happen in most management positions, but it depends on the industry. So when you've got that culture of, don't tell me about your feelings, I'm trying to get a solution here, what's that got to do with it? Why are you crying?
Which is really ironic.
How's that going to get us a solution?
Yeah, it's ironic because leadership is about influencing, and you can't do that if you're just talking about processes and you ignore the kind of human factor.
Well, as an employment lawyer, that's why I've really focused more on positive psychology, relationships, what's really going on here, because it is very, very expensive for businesses that ignore that. Because, if you ignore people's emotions, those emotions will come out one way or the other, and they may come out sideways. And look, the other reality that we need to get our head around as a country, let alone this worldwide trend, is the forces of the future labour forces are changing. The future of the labour force is that workforce planning is actually going to become more important than financial planning in the next 15 to 20 years, because all the baby boomers are retiring, and it's happening now. And you'll see that in the trends that are developing. It's hard to get good workers. There is a shortage of good workers, skilled workers. you know, artificial intelligence and robots are only going to, and outsourcing to the third world, that stuff is only going to deal with certain types of jobs. But those jobs that we have here in Aotearoa, they're jobs that require creativity, thinking out of the box, problem solving. Those are skilled jobs generally, because the rest are automated or outsourced. And so your workers are going to become very valuable, and more valuable as time goes by, because they'll be more scarce and there will be international competition for them.
Yeah, I think that's already happening in a lot of industries that are, you know, for example, the movie industry here. There's a lot of New Zealanders working overseas and just from New Zealand, for example, that because they're moving at such a fast pace. Same with technology-based work. I think that's absolutely right. And another thing that I have recently heard at a conference was around the shift of wealth from those baby boomers to their next generation. You know, they're passing on their wealth and their businesses because they're retiring and moving on in different various ways. But the knowledge isn't necessarily passing with them. So there is going to be a change in the kinds of jobs and what happens with both that wealth and the gap. And you're right, it is going to be an interesting shift in the future around that workforce planning.
I mean, 20% of the workforce is going to disappear in New Zealand because of that shift from being employed to unemployed. And that's a worldwide shift. So, you know, and I didn't discover this by myself. It was part of one of my favourite TED Talks is called The Upcoming Change in the World's Labour Force 2030. And fascinating stats about that. But if you apply those to New Zealand, at the moment there are 5 employed people for every 1 retired person. I think by 2020 there'll be 3 employed people for every 1 employed person.
And do you find more PG stuff with like the baby boomer age group or like younger workers?
I would say younger. What I found is baby boomers are a bit more old school, you know?
Very loyal.
Very loyal, kind of used to the boss being a bit grumpy and taking it.
They just handle it.
They do, and there's also fear of losing their jobs. It's harder when you're in your 50s. There's that perception that it's going to be really harder for me to get another job. So there's a bit more fear there and moving on. When they were young, if you didn't like your boss, you walked down the road, you got another one straight away, you know. But that has changed.
That's right.
Yeah.
And also people are shifting employers a lot sooner, you know, when that's a fairly old statistic that places were, you know, you'd stay your whole life at one job and now it's, you know.
Yeah. So, you know,
you get changed every 3 years. They actually recommend you shift roles every 3 to 4 years because you're becoming stale in that role, which makes sense to me.
So yeah, I mean the employers that value their workers, that value their people as people, you know, and take care of that emotional side, that relationship side, the healthy workplace side, they'll retain their workers, and they're the ones that are going to flourish and survive. Those that don't treat their workers well may not make it in the next 15 years.
So let's just say that we have somebody who has a grievance and they come to you and they sort of tell you the situation. They've left, for example, I'm just making this up, they've left because they found it untenable to stay. What are the sort of things that you're looking for in terms of what they should do to help themselves to build a case? Let's say they actually have a reasonable case. They're not making
in that case, that would be a constructive dismissal if they've come to see me after they've quit because I just couldn't take it anymore. So what I'd be looking for is evidence of what has happened to them during their employment. Often there's written evidence. There are emails, you know, that have gone back and forth, for example, between the manager and an employee or the manager and the group. There may be other employees that are still there, but often have left too, that would be willing to give witness statements witnessing the kind of treatment that was meted out or what happened. I'd also want to look at, obviously, their employment agreement and any policies around workplace bullying, disciplinary procedures, things like that.
So what happens if you've had conversations with your boss that that's where
just the two of you or something?
Certain behaviours, and things that come out when the door's shut.
Then it becomes...
What would you recommend?
Then it becomes their word against yours, right? Mm. So in the scenario you gave me, they've already left work. One thing employers need to be really mindful of these days is pretty much everyone's got a smartphone, which is a recording device, right? And it is not illegal to record a conversation in which you are involved in. It's illegal to record other people's conversations if they don't know you're recording. But a conversation you're involved in,
you can record it.
You can, and it's not illegal. And it happens a lot. And that evidence can be used at the Employment Relations Authority, which used to be called the Employment Tribunal. But at the authority, they've got very wide powers on what kind of evidence that they bring in, and they just love it. They can't help themselves. They always listen to the recording.
That's the real tip of the day.
Whoa, that's amazing. So if you're talking to the boss and they've been an egg and I hit record, I don't have to tell them. I just chuck it in my pocket or whatever else. And
that's right. But if you're the employer and you make a secret recording, that's a breach of your duty of good faith, and that's grounds for a PG.
Wait. I can't do it that side. So as an employee...
And the privacy, potentially privacy, isn't it?
Oh.
Yeah. So all employers... So often if employers come to me and go, okay, I'm going to have this disciplinary meeting, Ani, no, I don't need you there, and I'm going to take the minutes, it's going to be all good, right? What I say to them is, be aware you may be recorded. People do that. So just ask straight up, put phones on the table. Or you may say, let's record it so that you've got a copy of what happened and I've got a copy. But be aware you can be secretly recorded, and they have the right to use that. It's immoral, it's unfair, but it is not illegal.
Yeah. If you're the employer and you ask, can I record this? Mm-hmm. Is that all right? And they agree?
Yep, absolutely. But if they say no, then you have to respect that. Yeah? But there's nothing wrong with saying, okay, well, if I'm not going to do it, you're not either, let's put our phones away. Yeah? And then we write the minutes, and then you get them to sign those minutes before they leave the room.
Oh, why is that?
Before they leave the room.
Well, look, that's just been my practice, because I'm really fast at writing minutes. I've done a lot of it. So my practice is take the minutes, write it down, then get everyone there before we leave the meeting to sit, read through it, make any edits, initial any changes, sign it all off, and then give them a copy, go to the photocopier with a copy off to them, and off they go. If you're going to type up the minutes after the meeting, then my tip is that you get them done as soon as possible. You then email them to the employee or the employer from the other side and say, here's my draft of the minutes. Let me know if you've got any edits. If I don't hear from you from, say by 12 p.m. on Friday, so give them a few days, then I'll assume you're happy with the minutes and they'll be confirmed. So therefore you don't have to run around and get them to sign it off or wait for their feedback. Silence will be consent as long as they've had a reasonable time to check them. I hope you're taking notes here, Josh. I'm telling you, I'm saving you money here, Kari.
It's being recorded. It's being recorded here. Hey, where do we send our invoice?
We're all aware. We're all aware we're being recorded. Okay. Well, that's some great information there for employees and employers, Ani. So you told us that you moved back to law because you realised that you needed to have something a bit more passionate other than tax. But why did you choose employment law over other law? Weren't you first a barrister for a while, or are you still doing a bit of that? It's
been a journey with the law. I call it I've made peace with the law at last. So you'll both be aware of the last couple of years, it's been the expose about the workplace cultures and firms, sexual harassment, bullying, that kind of thing.
Well, Josh only actually knows because he's been part of this podcast. What I've realised is that a lot of New Zealand outside the legal industry,
the dodgy graduates going into summer school. And
yeah, they hear, but they don't care quite as much as we hope they do.
Oh, okay. Well, it's probably good. You tend to think your world is the centre of the universe. It took me a while to find the kind of law that worked for me and my personality and my style of doing things. So when I started at a very good, reputable, large law firm called Tauranga. It was one of the largest firms in town. And I started in the commercial law section because I was going to be the great brown hope for Māori economic development, That was how I was going to contribute to my people. But I found reading 20-page commercial leases excruciatingly boring, and I lost my love for commercial law very quickly, right? And so I shifted into litigation, and I found my niche with the law because I really love people. Then I shifted into criminal law. So I married another lawyer. We're now happily divorced, but he was a criminal barrister. And so when I left the firm, we went and had another little OE after we got married because, frankly, I was pretty burnt out by then. There's a lot of pressure in law firms. It's all about billing the 6-minute units and don't tell me about your feelings. I don't care about your feelings. Just get the case done, right? That can often be the harsh emotional reality in law firms. I'm not saying all law firms, but the majority, I would say.
That's what they're trying to really change and focus on now, aren't they? Theoretically.
Yeah, and if they don't, they won't survive.
Yeah, I agree with you. I don't think they will survive if they carry on that way. Yeah.
Yeah, because people have choices. They've got technology. Like, for example, me, I run a virtual law firm. I've got a website. I have meetings in town.
Yeah.
All you need is a laptop and an internet connection these days and a good experience. Yeah, so I moved into criminal law, loved that, great fun, get up in court, be a bit of a show pony, Once you get over the terror of the judge is going to yell at me for not knowing what I'm doing. But I got into criminal law and I loved that. And I went down home, I used to appear in a Pōtiki court, Whakatahane court, Tauranga, Waihi. It was great fun. But again, it was very busy and there is a tendency for lawyers and their personality types to burn themselves out, We're very driven and A-type personality kind of industry. And a lot of the talk in my generation now is about haora, balance, healthy life. But after criminal law, I got back into civil litigation and employment because the legal aid rules changed, and if I was really going to survive and support myself, I had to become a full-time trial lawyer, and I didn't want to do that. That wasn't my calling. And I had 2 young babies to look after. My twin daughters were 2 years old at the time. And the law is a jealous mistress, particularly criminal law. If you're in a trial, it's 24/7, and you need a husband at home to look after the babies. And mine.
I love that. A jealous mistress.
Yes, it is.
That is such a good, accurate term for the law. It is very demanding. Yeah, she definitely is a jealous mistress. Wow. So that kind of led you back into employment law.
Well, it's something I always had. I've always had it as part of my practice, and I just ended up specialising in it. It's become my niche. I'm kind of the Māori employment lawyer,
Yeah.
So the majority of my clients are Māori organisations or clients that have been with me a long time.
I wanted to ask though, what's the most difficult part of being an employment lawyer and what's the most satisfying?
The difficult part is, I think, the same as most lawyers who do litigation work would find, is people come to you when they're in crisis. They come to you, I've got this problem, please solve my problem. And they turn up with this huge, messy suitcase full of information. Here's the story, So the difficult part can be ingesting all of that information and sifting out what's important, what's not, what's relevant, and managing your client's emotions and helping them to process those emotions and focus on the ultimate goal and the outcome. The most satisfying part, which I think is also the same for most of my profession, is you really do get to help people. It is a privileged position that you have as a lawyer, and you have power and access to the law, and you can help. Some people achieve justice, not always, but that's always the goal. And a successful outcome can look different to some people. Some people, they may get no payout at all, but they got to stand up for themselves and look that other person in the eye and say, what you did was not okay, and I'm letting you know that, and I'm never going to let that happen to me again, and I'm going to role model that to my family and to my kids so it never happens to them either.
There's a very restorative element to it. But I also think that employees need to be careful not to do it unless they are really, really feel strongly about the injustice, because, and I'm interested to know, obviously, your views, Ani, it can affect the rest of your career when you move on to another role and people see that you've taken out a personal grievance, because quite often they will ask you either at the interview stage or the application stage whether there's anything like that that's gone on in your employment history.
Is that an assumption you're making, or do you have
an assumption that it's in that process? No, I think I've come across it. I think I've come across it myself. I've seen those questions, and I've often thought, if you're going to go down that path, you need to really be sure that that is the path and understand the potential implications.
I agree. And it's not just the future implications for your career, but it's also the time and emotional energy and financial investment in doing it. You really do have to have the fortitude and often the support to do it.
Yeah.
However, one of the realities is, kia ora. But one of the realities too is most of those PGs settle, and when they do, those settlement agreements are confidential. And often there are clauses in those confidential agreements, those settlement agreements, that say the parties will not make disparaging comments about each other. So the employers must give them positive references and say that they were great and say that they would employ them again. And that all matters around that settlement are confidential.
So they're completely confidential. So then what happens if you have to disclose to a new employer the existence? So you don't have to disclose the contents of a settlement, but the existence that a PG occurred and there was a settlement. See, that's still potentially...
All you can really say is there was a personal grievance and it was resolved and settled, and everything around it is confidential.
In a personal grievance, if the employee won, for lack of a better term, do they get the legal fees covered, or you can win and still have to pay?
Depends on the settlement agreement, doesn't it?
Well, there's two sides to that. If you go, say you go to mediation, most of them end up at a mediation conference, and if you resolve it, you sign up a settlement agreement. And the idea of the employee winning would be, so they get a payout and the employer recognises that they've done wrong and it's all signed up. Or if they can't settle things at mediation, they end up at the Employment Relations Authority. They end up at court, effectively. The employee wins if their personal grievance is upheld or supported by the Employment Relations Authority. And that's all very public, and that gets published. And they can get a contribution to their legal fees. There's a tariff, a kind of set amount that the Employment Authority usually awards. Like for a half day, you get about, I think it's $3,750, and for a full day, 4,500, blah, blah, blah. But they set the tariff. I'm sorry I didn't look up the exact amounts for our podcast.
That's okay.
Don't quote me.
Are there ever any real winners when those sorts of things occur, though? You know, we talk about who's winning and who's losing, but are they ever really, when you've gone through that process, it's a harrowing process for both sides, I would imagine.
It can be and it can't be. Look, I've been in mediation where everyone cries and gives each other a hug. Right? Often Māori ones, I'll say, you know. But I've seen both a good financial outcome, but more importantly, often for my clients, an emotional outcome, a restoration of their mana, of their dignity, of their self-esteem. And that has profound effects on their life going forward for them and their family, right? And that's part of standing up for yourself, saying that is not okay. Often breaking a pattern of a lifetime of taking treatment that you should not have been accepting, right? Comes out in your mahi, in your work.
So the restoration portion can be priceless, really.
It can, and that's one of the beauties of employment law. Most matters are settled at mediation, and we have amazingly skilled and experienced mediators who work for Mindy. Some of them working for over 20 years, they know their stuff, and it can be very healing for the parties involved. Not always, but that's what keeps it exciting, you know. You just never know what personality you're going to get. You never know what's going to happen, you know. That's the fun bit.
Yeah, okay. So can you tell us about an interesting case law or an interesting scenario that you've handled, and what sort of lessons were in that scenario or actual experience?
Sure. I'll troll my 20 years of war stories.
You'll have a few
Give
favourites,
us a good one,
surely.
one for the people.
Okay. Look, I'm going to give you my favourite one from a sentimental, I guess, from a heart perspective. So my favourite case involved the kohanga reo, kaiako, and kohanga reo, who will remain nameless, obviously. But this woman she'd worked for them for 9 years, and she's not Māori, but she had been adopted into the whānau. And then one day she started dating one of the manager's cousins, and the relationship didn't work out. And after that, she started getting treated differently. You know, she kind of got disciplined for things that other people weren't getting disciplined for, and public rallying. But because she was such a I'd say soft and compliant kind of personality, she just kind of took it. She just took it and hoped it would all get better. Then one day she came into work and she was called upstairs to have a meeting, and the manager's there, and the kohanga's kuia is there, and another one of the managers is there who happens to be the sister. You know, it's the two sisters in charge of the kohanga. And they say to her, yesterday one of the parents said that you were on your cell phone when two of the kids were having a fight and you ignored them. So we've decided that we're going to fire you. You're dismissed. Here's the dismissal letter that we wrote up yesterday and dated yesterday. And if you contest this, you'll probably never get another job in another kohanga reo again. Pack up your things and leave. Don't talk to the children. So she'd been there for 9 years, and that was that cut off. And she was a widow, supporting two, teenage children. And one of her children found her crying in her car on the way home. And what was beautiful about that is that she wasn't going to do anything about that. She was so emotionally devastated. She wouldn't leave her house for a while. But one of her mates, who was a mother at the kohanga reo, said, "This is not fair, this is illegal, and we're going to go see a lawyer and get this sorted out." My cousin Ani's a lawyer. We'll go have a chat to her, right? So we had a talk, and I felt out this woman, and it felt genuine to me, and I had a look at the evidence. So we ran that case, and we got a really good outcome for her. But the beautiful thing for her was that she got to stand up for herself.
Hmm.
And she got to look at those other women in the eye who had treated her really appallingly and unfairly and abused their power, and let them know it wasn't okay. And the other thing was the committee, the management committee at the kohanga had changed, and those that came in were shocked and appalled at what had happened as well. And they were very open about what happened and what was wrong. So she got all the money back that she lost from getting her wages cut like that, because she got no money for a while because when, there's a stand-down period, all that kind of thing. Mm. She went on to another job, but it was a change for her in how she was treated. And so sentimentally, that's one of my favourite stories.
So two things from that. One is, there's lots of family businesses and maybe employees should think twice about dating the managers related.
Māori, we're all related, Julia. It's a bit hard here.
And secondly, it's so important to have an advocate when you're in those. She was really lucky to have somebody who was in that environment that knew it was wrong and was a strong advocate for her to stand up. I think that's... And
the beautiful thing was the kohanga pulled their socks up after that, put some policies in place. Some good written employment agreements, Often that painful lesson brings positive change for the employer as well.
Yeah. Well, that's a great story. I can see why it was a heart story. I was welling up in
I
heart.
understand now why you're an employment lawyer, for the people.
So what's the most commonly asked questions that you get about law from non-legal friends and family, Ani? And what do you tell them? I'm sure you're at a party and they always come up and say, hey, I've just got this question.
Usually often it's about another type of law that I don't do, because lawyers are pretty useless, really. We don't really specialise in one area. You ask us about anything else, it's like, I don't really know.
Unless you're in an in-house and you've got to know a little bit about everything. And not a lot about anything.
And you've got to be careful about giving advice because they can hold you to it, right? You can get sued, so you've got to be careful in how you... But as an employment lawyer, I often get asked about 90-day trials, right? 90-day work trial. Right. Ani, what's going to happen? It's going to run out. And a common scenario is, it says I've got a 90-day work trial in my employment agreement, but I didn't sign it and return it until about a week after I started work. Is it still valid? And my answer to that is no, you're sweet.
Yeah, that's bad news for the employer.
It is. So, 90-day work trials are rigorously enforced by the courts because the judges don't like them because they take away people's rights to a fair process. So employers have to be very careful that when they've got a 90-day trial, they've got a proper clause in the employment agreement that says you're going to have a 90-day trial in accordance with this section of the Act, right? They've got to make sure that the employee signs and returns the employment agreement before they start work, and they don't even do an hour of paid work before they start.
That's the one.
And if they turn up at work and go,
most employers.
Oh, sorry, I left it at home, you go, well, you go home and get it because you can't start work till you return it. Wow. And the other thing that catches people out are the old pre-employment work assessment trials before you start work. Come into the cafe, make us a couple of coffees, and we'll see how you are at the job. And if we think you can make it, then we'll offer you a contract with a 90-day trial in it. Right? So employers have to be very careful when they're doing this sort of pre-employment assessments, come in and we'll suss you out before we give you a contract.
What's wrong with that?
You're already
There's
employed.
Nothing wrong with that. But 90-day trials only apply to new employees. Yeah, new employees. So if they've done an hour of paid work before they start, then they're not a new employee. So it doesn't account. So with those pre-employment
assessments... Is it only if you pay them? Can you just come in and work unpaid?
So you can't pay them. Right? Can't pay them.
Yep.
You've got to make it really clear. You're not going to get paid. There's no guarantee of work at the end of it. This is just an assessment. We're not starting your employment.
Yeah, right.
generally, if you want to be safe, you put that in writing and you get them to sign it. Often you don't get them to do tasks that are going to benefit the business, like work the tool, make sales. You're just assessing how they maybe do a couple of jobs. And there's no pay or promises, or I'll give you full money, or I'll give you this and that. And so they can be very, very tricky areas. It can trip people up.
Mm. Well, I think you've given some great tips for listeners today. But have you got any that are non-legal? Do you want to give? You know, like be good to your mother type?
I do, actually. Okay. I do. Yeah, besides the fundamentals, yeah, I do. One of the greatest things that I found about being an employee and what I talk about with employers is to recognise that people are built differently and that some people think differently to you. And sometimes it's not them, it's you. So the example I'll give is when I was working at the tax department in the policy department, I was a big picture sort of person, you know, big picture, strategic, goal orientated, but a bit more big picture. And I was working with a lot of people that were very detail oriented, you know, pragmatic, practical, dotting I's, crossing T's. So, and more introverted than I was. So I am introvert, as shocking as that may seem after this podcast. But so my perception of them was, you're a bit socially awkward and weird and hard to talk to, right? And their perception of me was, you're a bit flighty, you don't cover the bases, you know, you're not reliable. And they made us do this thing called a Myers-Briggs personality styles test, which was big back then. And we got to learn about, you know, this is how people's brains work. Some people are more introverted, some are more extroverted, some are detail-oriented, some are big picture. And we all need each other in order to get really good work done, you know. Introverts need extroverts and vice versa. Big picture people need people that cover all the details for them to get, so that their grand plan can actually work. So the tip I would give our listeners are, this used to cost thousands of dollars and take 2 days. Now it'd be like 5-minute, 10-minute quizzes on the internet. Yeah. And it can be a great insight into, this is how I operate. This is how this other person operates. And it's not because they're difficult or hard to talk to or bossy or whatever. It's just because their brain works differently to mine. So I'd recommend 16personalities.com. It's a great one. It's the old Myers-Briggs one. It's now on the internet, great fun, and you can read all about yourself, which is also fun. And the other one I'd recommend is the 4 Tendencies quiz by an ex-lawyer called Gretchen Rubin, which talks about what motivates people, what motivates you to do things and to not do things. Very insightful.
Very interesting.
Yeah, those insights, what they gave me was, it was areas for me to work on. So, because I was such a big picture person and I loved that, I've really had to work on covering the details as a lawyer, because if you don't have the details covered, you're going to lose. And the same with being more introverted, which can change. It can change day to day or over your lifetime.
Scenario to scenario.
Most people actually think of me as an extrovert these days, but I'm not. You know, I need quiet time to recharge generally. But I'm much more comfortable talking to people and talking to crowds, all that kind of thing. But I've worked on that, you know, and that's the cool stuff about it.
Understand that one. All right. Well, thank you very much. That's our latest podcast wrapped up and tidily done. And I just want to thank you again, Ani, for coming along and talking to us, and to my co-host Josh Brown. Thanks to our listeners, and a special thanks to Morgan Samuel for helping produce the show in the background. And just tune in next time. We're going to have another great lawyer on the show. And until then, I'm Julia Steenson, and from all of us here, take care and have an awesome day. Kia pai tō rā.